All right, let's go get yours. Good, they're getting a bunch of stuff done. I have one thing today. It's gonna be a mess.
All rise.
Everyone can have a seat. Have a nice lunch. You can call your next witness. Raise your right hand. You solemnly swear, affirm under penalty of perjury, your testimony in this case will be the truth, the whole truth, nothing but the truth. I do. Welcome back to the you may inquire.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Could you please state your name, spelling your last for the record?
It's Kevin R. as in Robert Davis. That's Davis.
Tell the ladies and gentlemen of the jury a little bit about yourself.
Well, I'm a retired law enforcement officer. In April of 2021, I retired from the Akron Police Department, where I'd been for 31 years. Prior to that, from 1982 to 1990, I was a deputy sheriff with the Summit County Sheriff's Department. My previous experience is in corrections with the Sheriff's Office, patrol with the Sheriff's Office, then uniform patrol with the Akron Police Department, Street Narcotics Uniform Detail, or Street Narcotics Unit, SWAT, and I spent about 19 years as a trainer for the Akron Police Department in the Training Bureau.
Are you married?
I am.
How long?
It'll be 25 years this year.
Congrats. Do you have any children?
I do.
How many?
3,
Any grandkids?
5.
Do you like being a grandpa?
The trick questions, absolutely.
I want to talk to you a little bit about when you're an Akron police officer. Can you give the jury a synopsis of the positions that you've held and the duties that those positions entailed?
Certainly. As I said, I started in patrol. That was Trick 4, which was 7:30 at night until 3:30 in the morning, where I worked some of the busiest districts in Akron. Somewhere around 1993, a new unit was formed called the Street Narcotics Uniform Detail, where I went to work about 6.5 years. Collaterally with that, I became a member of the Akron Police Department SWAT team. I did that for 12.5 years, where I rose up to be a team leader, and I became the lead instructor of the Akron Police Department SWAT team during my tenure. As I stated earlier, about 19 plus years as an instructor for Akron PD. During that time, I also taught at other academies, and I did things like use of force instruction, both the legal as well as the practical aspects of use of force, the suspect control tactics, and firearms. When I left the Training Bureau, I was the senior firearms instructor on staff. My last 3 years were spent as a detective with the body-worn camera unit, where I oversaw the implementation operations of digital video on the streets of Akron.
Are you self-employed as a consultant now after retiring?
I am. I own and operate KD Training and Consulting.
You've provided us a copy of your CV to detail your experiences and qualifications. Am I correct?
Yes, ma'am.
May I approach a witness, Your Honor?
Okay.
Let the record reflect that I am handing Mr. Davis what has been previously marked for identification purposes as Defendant's Exhibit U. Can you take a look at that document, sir?
Yes, that appears to be my current CV.
You mentioned to the ladies and gentlemen of the jury that you were, in your capacity in the Akron Police Department, you've been involved in the Training Bureau. Is that correct?
Yes, for a number of years, probably more than 20, but around there.
What else did you train in, if anything?
Well, I was also an adjunct instructor for the state of Ohio, the Ohio Peace Officers Training Academy in Richfield, Ohio. I taught for them for a number of years, everything from firearms instructor programs. I taught all new firearms instructors for the state, semi-auto pistol, revolver, shotgun, submachine gun, carbine. I taught use of force investigations, as well as tactical operations, low-light pistol, a variety of different courses.
What about classroom academics, sir? Did you participate in those types of training and service as well?
Yes, I taught in the basic academies in the city of Akron for Kent State and their basic academy, and for the University of Akron at one time in their basic academy. Those were hands-on as well as a classroom. And I taught in service in Akron, classroom setting.
What's the importance with regards to training? Why is there so much of it?
I would argue that there's not enough of it. Oftentimes it's due to budgetary constraints, but what we do know is that officers perform on the street in most cases as they have been trained to do. Training is vital to create a proper response of an officer.
Are you trained in the dynamic training?
This is called confrontation simulation training. We had, and currently law enforcement have, a variety of different training methodologies to make it as dynamic as possible. We have marking cartridges that fire out of simulated pistols that leave little paint marks on the role players. We create scenarios and use role players to make it as dynamic as possible.
Have you trained supervisors in the past?
I have in both use of force investigations as well as routine hands-on as well as legal aspects of use of force.
Why is that important?
Well, throughout the ranks, sergeants are your first frontline supervisors on the street. They respond and investigate the use of force to deem that the legal aspects as well as the policy and procedures of the department have been followed. And up the ranks, there's a checks and balances system. So a sergeant performs an investigation, submits paperwork, a lieutenant reviews it, and on up the ranks until the chief of police ultimately signs off on the use of force.
Now, you mentioned you have trained on use of force before. Have you presented at any conferences on use of force, specifically with regarding whether a decision to use deadly force was reasonable?
Yes, I have been a member of a now defunct organization called American Society for Law Enforcement Training. I am a member of ILETA, ILEETA, which is International Law Enforcement Educators and Trainers Association. I've trained at their conferences for going back more than 10 years. I've trained at CIPHER, which was another organization now defunct about the Society for the Investigation of Force and Reporting, and Performance Institute in Washington, D.C. on use of force investigations.
Have you presented in this state as well as other parts of the country, including Washington, D.C., with respect to this topic?
That's correct.
When did you start your consulting business, sir?
Well, actually, a number of years ago, I first testified as an expert, I believe it was 2002. And since that time, I've had inquiries, in terms of consulting and expert witness work, as well as training. So I do both. I train as well as consult.
Have you authored any articles on use of force?
Yes, I was an author, a freelance author for most of the major law enforcement periodicals, Law Officer Magazine, Law and Order, Police Magazine, a variety of different magazines, as well as 2 online portals for Police One and Officer.com.
Have you testified as a use of force expert here in the state of Ohio?
I have.
What about municipal court?
Yes,
Common police court?
correct, throughout Ohio and a number of different counties.
What about federal court?
Yes,
And have you been declared an expert before?
I have.
Have you worked in cases in other jurisdictions in the same capacity?
Yes, I've consulted on cases from Colorado through Florida, including Kentucky, Nebraska, Pennsylvania, Kentucky, pretty much a laundry list of states now.
Have you received any awards as a law enforcement officer?
Yes.
Which ones?
In 2018, I was the recipient of the Distinguished Training Award from the State of Ohio Attorney General's Office. And in 2019, I was inducted into the National Law Enforcement Hall of Fame as Trainer of the Year.
I want to talk to you about your consulting business and the process that you use to determine whether or not to take a case. When you make a decision to take a case in general, what process do you use in order to determine whether or not to take on that case in your consulting capacity?
Well, I don't solicit cases. I don't actively look for work. Most of my, all of my work is by word of mouth. I'll get an email or a call from an attorney, either a defense attorney or prosecutor's office that asks if I'm interested in working on the case. I then get the original discovery as much as I can get at the onset to make a decision whether that case is something that I could work on and help out with.
Do you have any criteria about whether or not you accept a case or reject a case?
Well, it strictly has to do with whether I believe the case has merit, that the officer's use of force in this context was within the law.
Have you received use of force cases and decided not to take them because it was contrary to your opinions?
Yes.
Why so?
once again, when it was clearly, I've seen everything from outright criminal acts by officers, sadly, to excessive uses of force. And once they exceed the law, then I can't defend them.
Have you examined use of force cases and found that a use of force was unreasonable?
Yes,
So just because you work on a case doesn't mean that you've formulated that an opinion at that point in time. Is that correct?
that's correct. Over the past year, I've turned down at least 6 cases.
Do you charge a fee to review a case?
Yes, I take a retainer,
What is that retainer, sir?
$3,500.
Is that industry standard?
It's actually cheaper than many experts.
Does that retainer fee come with an opinion attached?
Absolutely not.
Have you worked on cases and testified in cases on behalf of law enforcement officers?
Yes,
Have you worked on cases, either administratively, civilly, or criminally, with regards to actions when you were testifying against the officer's use of force?
that's correct.
And in our process, sir, when did I first reach out to you?
We had been working on another case here in Columbus, and your firm originally contacted me and advised me that this case was probably coming up. That was sometime after the incident in December of 2020.
And I didn't provide you any type of material at first, is that correct?
At first, no.
And when we asked you about the situation, or after we talked initially, did you eventually ask us to provide you with those materials?
Yes.
Did you receive those materials?
Extensive, a laundry list of materials, yes.
Was that over a short period of time, a long period of time?
It's been over a period of time, but there is a considerable number of files that I received.
Were you eventually provided all the relevant information you saw fit in order to come to a conclusion in this case?
Yes,
Did you make us aware of your potential position?
I did, yes.
Were you asked to prepare a report?
I was, yes.
Do you charge a fee to testify, sir?
I do, yes.
What is that fee?
$2,500.
Is that industry standard?
Once again, it's cheaper than a lot of experts.
May I approach the witness, Your Honor? Let the record reflect that I am handing the witness what has previously been identified, marked for identification purposes, as Defendant's Exhibit B. Sir, I just handed you your report that we asked you to prepare in this case. Is that correct?
It appears to be a copy, yes.
Is it a fair and accurate copy of the report that you wrote and prepared for this case that occurred back in December 4th of 2020?
It appears so, yes.
Now, I'd like to walk you through your report. Before we get to your opinions, I want to talk to you about the authority behind your opinions. What authority do you use, sir, to make an opinion about a use of force case?
Well, we're primarily talking about the authority under law, so we would talk about the constitutional standards, the Supreme Court standards on use of force, as well as state standards. It can be, we can look at policy and procedure, et cetera.
Objection, approach.
You may. get set up.
Your Honor, with respect to the objection that was discussed at sidebar, may we note a continuing objection to his, the line of questioning on these issues for the record?
So noted.
Thank you.
May I proceed?
Yes, you may.
Thank you, Your Honor. Where we left off, Mr. Davis, we were talking about the authority that you use in order to analyze a case. I believe you were discussing the Supreme Court cases. What Supreme Court cases are those?
Well, in order, it would be Tennessee versus Garner, which was decided by the Supreme Court, and Graham v. Connor.
And you said both of those opinions were rendered by the Supreme Court?
That's correct.
What about here in Ohio? What case do you use in order to review a use of force situation here in our state?
That's State of Ohio v. White.
Why is White so important in the analysis with regards to uses of force here in the state of Ohio?
Well, Graham v. Connor was a civil case, not a criminal case. And in the White case and the Ohio Supreme Court's decision in White, they applied Graham v. Connor and Tennessee versus Garner to criminal cases in the state of Ohio.
Now, before we get to the information that you relied upon in coming to your conclusion here in this case, I want to talk to you about how you analyze a use of deadly force case with respect to Graham v. Connor, Tennessee v. Garner, and State v. White. Is that okay?
That's fine.
Do you use Graham and White and Garner to analyze the use of deadly force?
Yes.
Because why?
Well, those are the legal standards. They're taught in throughout Ohio and police basic academies. That's in the curriculum developed by the state of Ohio that needs to be taught.
So the Supreme Court cases are taught to police officers. Am I understanding you correctly?
That is correct.
And have you instructed on Graham v. Connor, Tennessee v. Garner, and State v. White?
Yes.
Give the jury a rundown on how you train officers with respect to Tennessee versus Garner.
Well, Tennessee versus Garner was the first time that the Supreme Court looked at use of deadly force involving, it involved the shooting of a fleeing felon and applied the Fourth Amendment. The Fourth Amendment has to do with unreasonable searches and seizures. So the Supreme Court in Garner said that the shooting of the decedent in that case was a seizure, and because of that, the objective reasonableness test of the Fourth Amendment applied.
What about Graham, sir? How do you have to confine your analysis with respect to Graham versus Connor when you're examining a use of deadly force case?
Well, Graham v. Connor built on Tennessee versus Garner and applied the Fourth Amendment to seizures involving non-deadly force. However, both Tennessee versus Garner and Graham v. Connor are widely applied to use of force cases, deadly and non-deadly, throughout the United States by law enforcement.
Are there factors that Graham versus Connor tells you to examine when analyzing a use of deadly force?
Yes, there's what they call the Graham factors, and there's 4 of them, but they're have been described as a non-exhaustive list.
What about State v. White? Did State v. White expand on Graham versus Connor?
Oh, yes, State v. White applied to some foundational principles not found in either Garner or Graham.
Are there additional factors that the state of Ohio provides experts like yourself with respect to analyzing a use of deadly force case?
Absolutely. In State v. White, there is references to not only the use of deadly force or the threatened use of deadly force by a subject against law enforcement, but also the perception of the threat of deadly force. So White expanded that and gave some better guidelines on the use of deadly force to law enforcement officers in the state of Ohio.
Do you analyze those factors when you're coming to a conclusion with respect to a use of force case?
Yes, I've used them to analyze and also cite them in my report.
On the principles at play here that you have to use analyze a deadly force case, what principles does the law instruct us to use with respect to use of deadly force?
Well, in Ohio, we have not only the Tennessee versus Garner, the application of deadly force in that case, but also State v. White talks about the principles that the officer has to have a reasonable suspicion that his life or the life of another is being threatened by death or serious bodily injury, or have probable cause to believe that the suspect has committed a crime involving the infliction or threatened infliction of serious physical harm, and deadly force is necessary to bring him to prosecution. That's Garner. That was parroted and cited by the Supreme Court in Ohio in the White case.
What about hindsight, sir? Can you use hindsight in your analysis when analyzing a use of deadly force?
No, both the Supreme Court in Graham as well as the Supreme Court here in Ohio in the White case say that, and we have hindsight bias, knowing the outcome. We look back, and both courts have said that that's not to be done in terms of the decision to use deadly force or our decision on whether that was appropriate use of deadly force.
Whose perspective do you have to use when analyzing whether a use of deadly force was reasonable or unreasonable?
The officer involved standing in their shoes at the moment that force was used.
Do these guardrails that we just spoke about speak to actual possession of a weapon?
No, it's what we have to remember is that both cases are based on officers' perception of the risk of death or serious bodily injury. In other words, it can be, based on the totality of the circumstances, reasonable for an officer to use deadly force against an unarmed subject if they reasonably perceive that they're a threat of death or serious bodily injury.
What about mistakes, sir? What does the confines of which you're to confine your analysis of speak about with respect to mistake?
Well, the White case is pretty explicit about that even though, upon investigation of the incident afterwards, we find that the subject was not armed or had an innocuous item like a cell phone or comb or something like that, that the decision at the moment force was used was reasonable.
Right. Now that we talked about the guardrails for which you're to confine your analysis to, I want to talk about the information that you had while analyzing this case. What information did you review?
Well, everything that was given by your office, I forget how many different files. There are 160 some, 180. The total number I can't recall. Some were receipts for paperwork or what have you, but the bulk that I looked at was the circumstances on scene as described by the officer involved and other officers that were present, the forensic evidence, i.e. the crime scene photos, body-worn camera videos, and statements of officers that were on scene once again.
Have you gone to the intersection of Carl and Ferris Road?
I have. I've drove the route, not only driven by Mr. Goodson, but also by Deputy Meade.
Have you gone to 3996 Estates Place, the home that is the subject of this case?
I did. I did about 3 different sweeps to drive by and get the layout of the land per se.
Why is that important, Mr. Davis?
Well, photographs are only 2-dimensional images. You don't really get the depth and the distances and everything. It really helps you to see the distances involved in the environment in which the encounter took place.
Now, when you arrived at the intersection and drove both of those routes, went by the scene, tell the jury your overall impressions of that scene, of that route, of that intersection.
Well, it was busy because school was letting out, so there was a lot of cars there at the intersection of Ferris and Carl. But I was taken by and usually am, by the fact that the distances in real life are shorter and closer than they are depicted on video or by the pictures.
Do you normally find that in your practice, that the pictures don't do the scene actual justice?
Yes.
Based on the discovery, the case file that was sent to you, going to see the scene, your experience, training, and expertise, did you formulate, sir, an opinion as to whether or not the use of force was reasonable as it relates to Mr. Meade?
Objection.
Overruled, but note your objection.
Yes. What is that opinion, sir?
Based on the totality of the circumstances at the moment that Deputy Meade fired, that it is my opinion that it was a reasonable use of force.
I'd like to direct your attention to the part of your report where it talks about jurisdiction, authority jurisdiction. What does that mean for the jury?
Well, in order for a law enforcement officer to enforce the laws of the state of Ohio, they have to be a duly commissioned and certified law enforcement officer. And Deputy Meade was that, in addition to having the authority being sworn in as a deputy U.S. Marshal on the task force.
Next, you talk on page 9, I apologize, the lawful objective for taking action. What do you mean by that?
Well, the foundational activities of Deputy Meade, were they lawful? And clearly, based on his perception of Mr. Goodson's activities in the car and on the street, on the state's place, that he did have a lawful objective for taking action.
What does an officer need in order to be able to investigate a suspect?
Well, he can have a mere hunch to investigate. That would lead to a voluntary consent stop. Say, excuse me, sir, can I stop you or can I talk to you? And the person consents. That happens all the time. Next up is reasonable suspicion to believe that a crime is being or about to be committed, and the person that you're going to stop is the one that did that. That reasonable suspicion is in Terry v. Ohio, which allows officers to detain subjects that they have reasonable suspicion committed a crime.
What about to make an arrest, sir? What does an officer need in order to make a lawful arrest?
Probable cause, based on the laws of the state of Ohio.
Did you find, sir, that Jason Meade had a lawful objective for taking action here?
Yes.
How so?
Well, he witnessed what would be weapon violations and actually menacing or even assault by Mr. Goodson while in the car. You can't point a handgun at other motorists or at law enforcement officers. That's against the law.
Objection.
I'll vote your objection overruled.
I want to talk to you about, in your materials that you reviewed, once the car stopped and moved, my understanding is that you reviewed material that a person with a gun in his hand went toward 3996. Is that correct?
That's correct.
At this point, how did you take that into your analysis?
Well, certainly, once again, we have reasonable suspicion, or I believe probable cause, that a crime has been committed, and that Deputy Meade had the lawful right to investigate, to stop that vehicle or stop that person. And certainly the presence of a weapon increases the potential risk to the officer, to Deputy Meade.
Does it increase the risk to anybody else?
Oh, yes. Anybody that Mr. Goodson can run into or on the street or on the sidewalk, et cetera, could have perceived him to be a deadly threat, walking with a gun out or having a gun out.
What does training tell that Deputy Meade has to do at that moment?
I'm sorry, can you re-ask the question?
I apologize, it was a poorly worded question. Pursuant to training, what is Deputy Meade supposed to do when he sees a person waving a gun at an intersection?
Objection. May we approach?
You may. You may inquire further. When,
No problem. How is an officer trained to respond to a person waving a gun in a vehicle?
Well, this is, we pay officers to investigate such things. This is what they do. This is to investigate as to whether there is criminal intent on the part of the subject, whether there is a risk to the public at large, and to ultimately, if they deem that they have probable cause, to arrest the person for whatever violations of law.
How are officers trained to respond to a person running away from them with a gun?
Well, this is a highly dangerous situation for the public at large as well as the officer. And officers can attempt to pursue that individual, and oftentimes do pursue them, even at the risk of their own death.
Is the person who is running away allowed to be non-compliant?
No, people do not have the right to resist lawful arrest or detention.
Does it matter, sir, if the person running away can't hear the officer?
I don't know how the officer would know that under those circumstances.
Does it matter if the person who's running away has a CCW permit?
No, it wouldn't matter. Unfortunately, people with permits shoot at other people unlawfully and do other actions, so no.
Does an officer have to wait before approaching this armed person?
Wait?
Yes, sir.
No, they don't have to wait there. That's what we pay them to do. They're paid to act.
Anything else, sir, with regards to the lawful objective for taking action with respect to this case?
No, I don't believe so.
Did you find that Jason Meade had a lawful objective for taking action with respect to this situation?
Objection.
overruled, but note your objection.
Yes.
I'd like to discuss the next part of your report, sir, where it talks about circumstances. I believe in your report you discuss circumstances are tense, uncertain, rapidly evolving. Why do you include that type of analysis in your report?
Objection.
Basis?
May we approach?
Gil, I'm gonna have you in a running suit now. You may inquire.
Thank you, Your Honor. You include a section in your report about the circumstances, and I believe you deem it as tense, uncertain, rapidly evolving. Tell the ladies and gentlemen of the jury why you have that in your report.
Tense, uncertain, and rapidly evolving is referred to by the Supreme Court in a Graham decision. It says that officers are oftentimes forced to make decisions in circumstances that are tense, uncertain, rapidly evolving about the amount of force that they find necessary.
And what did you find with regards to this case with respect to those factors?
Well, when we balance those, we find that it was extremely tense, uncertain, and rapidly evolving. The time constraints here were seriously reduced, and the threat, because of the threat of death or serious bodily injury, the decision-making was compressed.
Now, you mentioned earlier about the Graham factors. I'd like to discuss those Graham factors and how they came into your analysis. Factor one, what is the first factor that you analyzed?
The severity of the crime at issue.
What is the severity of the crime at issue? Tell the ladies and gentlemen of the jury what you mean by that.
Well, although the pointing of a gun at other motorists or at the deputy is not seriously violent, it has the potential of violence. So it is the severity is high in terms of the potential outcome, once again, of death or serious bodily injury.
What about the second factor? What's the second factor?
The second factor is whether the suspect poses immediate threat of death or serious bodily injury.
And what did you find with respect to that factor in this case?
At the moment that Deputy Meade fired on Mr. Goodson, that situation was an immediate need to shoot to save his own life.
Can you think, sir, of a higher threat than when a gun is pointed at you as a law enforcement officer?
With bullets coming your direction, that would be the only difference.
What about the third factor you examined?
Whether the subject actively is resisting or attempting to evade arrest by flight.
And what did you find with respect to that factor in this case?
Well, we can only go on the deputy's perceptions. That's what this is all based on, his perceptions of that. And it appears, and based on his...
Your Honor.
Yes.
Sorry.
Mr. Davis, we were talking about the other factor that you analyzed of being whether the suspect resisted or attempted to evade arrest. You were discussing about how you have to interpret it from the eyes of the officer on the scene. How did this factor relate to your analysis, and how did you come to your conclusion regarding this factor?
Well, it was Deputy Meade's perceptions as indicated by his statement that he believed the subject was actively fleeing attempts for the deputy to confront him or to detain him.
Now, we're going through all of these factors. Is that what you have to do pursuant to the analysis with respect to the use of deadly force?
That is part of it. It's the Graham factors, and because the Supreme Court talked about it, we make sure that we cover those in an analysis. But there's so much more to an analysis of the use of force.
What else goes into the analysis of the use of force?
The environment, in terms of the lighting, the conditions, the number of other subjects, the number of officers, the exhaustion potential. For instance, if an officer is actively engaged in fighting a subject, they tend to exhaust after about 15 seconds. That affects and impairs their decision-making. The compressed nature of action, response time, et cetera, all these things are factored in.
I want to talk about another factor you discussed, the possibility that the suspect may be armed. Did you analyze this factor when you came to a conclusion here?
Yes.
What did you find with respect to this factor?
That Mr. Goodson was, in fact, armed.
So it wasn't a possibility?
No, it was not a possibility. He was, in fact, armed.
What about duration of the confrontation? Do you take that into consideration at all?
Once again, decisions, we would love for officers to have extensive time to make a decision, but the onus is on the subject because the officer can only react and respond to the conditions that the subject creates.
Did you find that Jason Meade responded to Casey Goodson's actions on December 4th, 2020?
Yes, I finally responded, correct.
I want to switch gears and talk about human factors and how these could potentially impact an officer's perception of severity of the crime.
Objection, Your Honor. Reapproach.
Yes.
We were discussing human factors and how they come into your analysis. Tell the ladies and gentlemen of the jury, have you studied human factors before?
Yes, especially in the context of law enforcement violent encounters. I've studied human factors for more than 25 years and taught on the subject. In addition, I'm a force science analyst and have studied with Human Factors Research Group.
Have you trained officers on human factors before?
Yes, throughout my career.
Have you trained supervisors of law enforcement officers with respect to human factors?
Yes, throughout my career.
Why is it important to train on human factors?
Well, oftentimes you have performance deterioration or performance issues under stress. You have cognitive changes that take place. Imagine that you're walking on the sidewalk and a car has jumped the curb and careening towards you. The way your brain works, your senses, the decisions you make, your movement, et cetera, is all factored in by human factors.
What types of human factors are we talking about, Mr. Davis?
Well, in this context, and under these circumstances, Deputy Meade would have perceived the threat and a branch of what we call the autonomic nervous system is the sympathetic nervous system, which is essentially fight or flight.
Objection, Your Honor.
Overruled.
This fight or flight mechanism or body alarm reaction, as it's known, changes things. For instance, we used to call it tunnel vision and tunnel hearing or auditory exclusion, but it's really just perceptual narrowing. In other words, things go down in the tunnel because that person with a gun directly in front of you is the subject of possible death. So you don't care about these things to the outside. Your brain may perceive them, but you don't actually think about it. It narrows down. It changes the way that you make a decision. It can impair your performance in terms of wicking blood away from the extremities to prepare yourself for mortal combat, et cetera. Then we have other human factors involved in terms of memory and the impact of SNS or sympathetic nervous system on what you remember post-incident, et cetera. So there are a variety of different impacts of the sympathetic nervous system and human factors on performance.
Did you take into these factors when you came to your conclusion in this case?
It can explain many things. It can explain everything from why witnesses have different versions of events because of distortions or that perceptual narrowing. You could have black holes or sections of your memory that you just can't remember properly, et cetera. So all these things are factored in when we look at this, because that's at the moment that the officer used force, deadly force in this case, the question is, was it reasonable? And we have to factor that in to make that determination.
Thank you. I want to talk to you about, can a person ever be a threat with their back towards you?
Yes, people move, so it can start out, and this has been extensively studied, where a subject, they call it 180-degree front to back, where a subject with a gun turns 180 degrees and turns back, and the rounds are subsequently hit the subject in the back.
Objection, Your Honor. There's absolutely no foundation for that.
You can re-ask the question.
Can a person be a threat with their back towards you?
Absolutely.
Why so?
Because it takes a small movement. I'm aware of one shooting in which it was a flick of the wrist and an officer was shot and killed. So it doesn't take the person being frontally aligned with you to present a deadly threat. Also, they can present a deadly threat to you and turn subsequent to that. And, once again, the rounds may impact in the back or otherwise.
Again, objection, Your Honor.
Overruled.
How about when an officer sees a gun being leveled in his direction? Is that person a threat to the officer?
Absolutely.
How so?
Well, guns are projectile weapons. They fire bullets, and that bullet can literally go on to the point it eventually drops to the earth. So an officer can be at risk of death, and even extended ranges. It doesn't have to be close up. So a person with a gun is a deadly threat.
Do you train officers to kill?
No,
Do you train them to injure?
no.
What do you train them to do?
The common terminology in firearms training is we train officers to stop the subject, to stop their homicidal actions against the officer.
Is an officer trained to shoot at center mass?
Center of mass. That means that the center area of the target presenting itself. If the person is sideways and pointing the gun sideways, then the center of mass would be the side of the person. If the back was towards the officer, that would be the back. So it's center of mass, not center mass.
Thank you. If a person hits at center of mass, shouldn't that officer know for certain that that person is going to be incapacitated?
No, I think research has shown that about 85% of all people that are shot with firearms, the people that die are due to exsanguination or blood loss, and that takes time. It takes time to lower the blood pressure until the person collapses, et cetera. And we've actually had recorded cases, and it's commonly taught in law enforcement, where subjects have received a mortal wound and still gone on to kill the law enforcement officer.
I want to switch gears and talk about Seth Stoughton for a second. Do you know who Seth Stoughton is?
I do.
Tell ladies and gentlemen of the jury how you know who Seth Stoughton is.
Mr. Stoughton has come onto the scene in terms of use of force nationally just over the last few years. And he is, I know, a professor of law in South Carolina, but also has written quite a bit and has written a book on analyzing use of force.
Have you read his book?
Objection, may we approach?
Yes, I guess.
What's the objection? Can you state the objection?
Criminal Rule 16.
You may continue.
Have you read Mr. Stoughton's book?
I have, yes.
Have you had an occasion to review his report?
I have, yes.
How is he involved in this case?
He was, it's my understanding, he was hired by the prosecution as their expert.
With respect to tactics, Mr. Davis, did tactics come into your analysis at all with respect to the use of deadly force here?
There's a range of tactical things that officers can do. The question is was it lawful? Everything, in my opinion, that Deputy Meade did was within the law. There's nothing to say that, and White, State of Ohio v. White specifically says that, you know, the most erudite expert witness, when looking in hindsight, cannot say what an officer could have, should have, or might have done. The question is, at the moment that he used force, was it within the law?
You said not could have, should have, or might have done then.
That's correct. And when we're talking about tactics, those are things that there's no law. Graham v. Connor doesn't refer to tactics at all. There's nothing in the law that talks about officer tactics in terms of what they do. certainly when you're confronted with a subject that has a gun and you're approaching that person, that tactically it's smart to have body armor on, it's smart to have some type of firearm out and ready. Those are all sound tactical principles.
With respect to the reasonableness of whether or not an officer can use deadly force or not, do tactics come into play at the moment that the officer uses deadly force?
No, the State v. White specifically says that we look at that event specifically, not rearward. In other words, it cautions against using these examinations of tactics, because we could always, with hindsight being 2020, we can all look back and say, oh, if he would have only done this or that, but that's not how the law works.
So tell the ladies and gentlemen of the jury how they're supposed to ignore, or how do you ignore hindsight in this analysis?
Well, I investigate the totality of the circumstances and make a determination of whether the use of force was within the law at the moment that it's applied.
So the totality of the circumstances, tell the ladies and gentlemen of the jury exactly what you took into account here in order to come to your conclusion.
Well, number one, Deputy Meade was confronted with an armed suspect. Mr. Goodson had a gun. Number two, the gun was in his hand from the facts and evidence. Number three, Deputy Meade testifies that Mr. Goodson moved towards him. Any movement towards and with a gun in hand can reasonably be perceived by an officer as creating a threat of death or serious bodily harm. So all of those things, are factored in at the decision to make deadly force.
Whose
To use
perspective?
deadly force.
Whose perspective do you have to look at that from?
The law says in the officer's shoes.
What about Mr. Goodson? Doesn't his perspective count?
No, Mr. Goodson created the circumstances which led to the shooting.
Sir, what were your findings with regards to whether my client's use of force was reasonable?
That based on my examination of the facts and circumstances, that at the moment he used force, it was reasonable based on the law, based on his reasonable perceptions as well.
Thank you so much, Mr. Davis, for taking the time to come and speak with us. I have no more questions for you at this point. I'm sure Mr. Shaw has some questions for you, though.
Thank you.
Council want to approach without you. You're not invited to this party.
Afternoon break. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it is finally submitted to you. About 15 minutes. We'll go have a seat. Everyone can have a seat. Any cross-examination?
Yes, Your Honor. May I proceed? Thank you. Good afternoon, Mr. Davis.
Good afternoon.
Start my questions by asking you about State versus White. That's a really important.
To the state that it wasn't included in the curriculum. Yes,
Yes, I mean, it's an Ohio Supreme Court case, correct?
that is correct.
And it defines what the rule is for evaluating a police officer's use of force in the context of a criminal case, right?
That's correct.
So that's the scenario that we have here, correct?
That is correct.
So I want to talk about, and you're very familiar with the case, aren't you, based on your consulting and your training and experience?
I've reviewed the case extensively, yes.
Okay. So in paragraph 25 of the case, isn't it correct that the Ohio Supreme Court wrote that courts therefore applied Garner and Graham in reviewing criminal convictions arising from a police officer's use of deadly force? Is that correct?
I don't have a copy of it, but
May I approach, Your Honor? I'm going to hand you what we've marked for identification purposes as State's Exhibit 31.
okay.
If you would just take a moment to review that, sir.
Your question was on what page in reference to what?
It's on page 6 of 23, paragraph 25, which is at the bottom.
Okay.
Now, did you look at all the pages of this document that I handed you?
Right now, I have not, but I will if
What I'm getting at is I just want to make sure that we agree that this is a fair and accurate copy of the Supreme Court's decision in State versus White.
that's correct.
Thank you. It appears to be from a commercial legal database.
Not LexisNexis, which I'm familiar with, but yes, it does.
Okay. I guess the formatting must have changed between what's available, because this is actually, I'll represent to you, this is from LexisNexis.
It must have changed.
So again, are you with me on page 6 of 23?
I am.
So on paragraph 25, the Supreme Court wrote that courts therefore apply Garner and Graham in reviewing criminal convictions arising from a police officer's use of deadly force, correct?
That is correct.
So then, moving to paragraph 48, I'll direct you to page 12 of 23. Some more important guidelines that the Ohio Supreme Court has given us in these contexts. And it says there that because a police officer's justification to use deadly force is limited by the Fourth Amendment, the appropriate instruction on deadly force is taken from Tennessee versus Gardner, and I'll leave out the extra citation information. Court goes on to say, Garner establishes that where the officer has probable cause to believe that the suspect poses a threat of serious physical harm, either to the officer or others, the officer does not act unreasonably by using deadly force, correct?
That's correct. I testified to that earlier.
Thank you. I believe you mentioned something in your testimony about reasonable suspicion versus probable cause. Maybe I misheard you, but I just wanted to clarify that this is the rule in Ohio, that we look at Tennessee v. Garner, as well as the factors that are set forth in Graham versus Connor, in evaluating whether an officer's use of force is reasonable, whether it's deadly or not deadly, right?
What I testified to was circumstances that would allow an officer to detain a subject, lawfully detain a subject, short of probable cause, and that's reasonable suspicion to believe that a crime has been, is being, or about to be committed. An officer can therefore lawfully detain.
So that's contrasting the rule that we were discussing for the use of force then. We mixed those up, and you've clarified that now, correct?
Correct. An officer could have reasonable suspicion to stop someone, and then that person subsequently draws or attempts to draw a firearm, or the officer perceives that the subject is doing that, they then have probable cause to use deadly force.
So the takeaway point that I want to clarify and make sure that you agree with is that in the state of Ohio, we look at Tennessee versus Garner and Graham versus Connor, and describing the standards that we look at for evaluating an officer's use of force, correct?
That is correct.
Draw out a little bit more information from that decision. Graham versus Connor, in that Supreme Court case, says that the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with the 20/20 vision of hindsight, correct?
That's correct. The question is, would a reasonably prudent and well-trained officer in the exact same circumstances have used that amount of force?
And the court describes what that inquiry involves, correct?
Can you add to that question? I'm not sure what you mean.
I can. Let me just give you the quote from Graham. Is that all right?
Certainly.
So in Graham, the Supreme Court wrote that the reasonableness inquiry in an excessive force case is an objective one. The question is whether the officer's actions are objectively reasonable in light of the facts and circumstances confronting them, without regard to their underlying intent or motivation. An officer's evil intentions will not make a Fourth Amendment out of an objectively reasonable use of force, nor will an officer's good intentions make an objectively unreasonable use of force constitutional. That's what the court says, correct?
That's correct. The objective test is without regard to their underlying intent, motivation, anger, et cetera.
So it's fair to say that if it's without regard to their underlying intent, an officer could say, I used force to stop the threat, but if their use of force was objectively unreasonable, even though their subjective intent was to stop the threat, if it's objectively unreasonable, then that's what it is, because we don't look at the officer's motivation and their conduct, correct? We just look at the facts and circumstances confronting the officer.
We have to view totality of the circumstances at the moment that the officer used force. The standard that we use to examine that is an objective standard. It has to be reasonableness or what a reasonably prudent and well-trained officer would have used.
And that's based on the facts and circumstances confronting the officer, correct?
That is correct.
Okay. There was some language that came out in that quote from Graham where we're saying Fourth Amendment. And by Fourth Amendment violation, when we talk about it in this context, we're talking about excessive force, correct?
In this context, yes. An unreasonable seizure in terms of the use of deadly force.
Now, I want to circle back to a point that you were making earlier about the various authorities that officers have to use their authority as an officer to stop someone, et cetera. And I believe you mentioned in your direct testimony that an officer can have a mere hunch and attempt to talk to somebody, correct?
Yeah, officers can approach anybody and have what we call a consensual stop. In other words, excuse me, sir, can I stop and talk to you? The guy says yes, then that can develop into something more or not, but they can certainly have consensual contacts with subjects.
And then the next step is what you described. It derives from the United States Supreme Court decision of Terry v. Ohio, correct? Terry
Correct.
stops.
A Terry stop based on reasonable suspicion, correct.
And what the court specifically said in Terry v. Ohio is that reasonable suspicion has to be more than a mere hunch, right?
That's correct. The officer has to be able to articulate that the subject has been, is being, or about to commit a crime.
And there's a pretty significant difference between having a hunch and having reasonable articulable suspicion that criminal activity is afoot, correct?
Those would be based on the facts and evidence as developed by the officer's senses.
No, but again, the implication is that if there were a stop and a court were to find that the officer had only a mere hunch, there's ramifications for that, right? There would be a Fourth Amendment challenge to their motion to suppress because the officer did not have the authority to stop someone. An officer does not have the authority to stop somebody on a mere hunch, correct?
Forcibly stop someone, yeah, that's correct. They have to have at least, in terms of forcing someone or detaining them against their will, they have to have at least reasonable suspicion.
So it's fair to say that if an officer has just a mere hunch that criminal activity is afoot, he cannot use a show of authority, whether it's a flashing light on the cruiser, his voice, displaying the duty belt. He can't use any of those tools to stop someone. The officer could ask someone to stop and they could just walk away, correct?
I think you're conflating two different issues. And officers always, especially uniformed officers, or in this case, a detective or a U.S. Marshal wearing a tactical vest with signifying U.S. Marshals, et cetera, that is a show of authority. So they always have that. And you can turn on your lights on a car just to check out something that you have a hunch, what's going on here, but you can't forcibly detain someone unless you have reasonable suspicion.
Correct. So if an officer has a mere hunch and they ask someone to stop, that person can just walk away from the officer, correct?
That's correct.
Thank you. Now, you mentioned that, of course, the facts and circumstances facing an officer is critical for evaluating the use of force. Now, isn't the credibility of the officer's account of those circumstances at issue too in these cases?
Well, it has to be compared to the facts and evidence, the veracity of the person, or whether the person appears to be, honest or telling the truth is compared to the facts and evidence.
So then your answer is yes. An officer's credibility is one of the factors that has to be considered when evaluating whether their actions were objectively reasonable.
One of the reasons, yes.
So in this case, you looked at the facts and circumstances confronting Mr. Meade at the time of the incident, correct?
Yes.
So I want to start by looking at your analysis of Mr. Meade's observations of and actions towards Casey Goodson when we're talking about the intersection of Carl and Ferris, okay?
Okay.
So you asserted in the report that you wrote, based on your analysis of the materials provided you by the defense, that the criminal actions of Goodson while armed in his vehicle at the intersection gave the defendant every legal right and authority under Ohio law to investigate, stop, and arrest Goodson, correct?
That's correct, based on Deputy Meade's written report or written statement of what transpired.
Now, suppose the facts, because again, you're just looking at a written report. You are not aware of what facts have been adduced at the trial in this matter that's currently occurring, correct?
No, I'm not aware of testimony, if that's what you mean.
Yes. So suppose the facts actually show that the facts confronting the defendant on that day showed only that Goodson was holding his handgun in his hand as he turned at the intersection. If that were the case, if the facts establish that and that's the finding, would a reasonable officer acting under generally accepted police practices taking a different course of action if he's just holding his gun while he turns in the vehicle?
I don't know how a reasonable officer could conclude that it was innocuous when he looked over and saw a gun being waved around in traffic. I don't understand that.
Well, that's not the question, so maybe that's why you don't understand. Again, the question is whether, if the evidence showed that he was merely holding the gun in his hand as he's trying to negotiate the turn in his vehicle, would a reasonable officer have reason to stop him?
Yes, he still is improperly handling a firearm in a motor vehicle.
But on December 4th of 2020, Ohio had a CCW regime, right? So under Ohio law, an individual could obtain a CCW license, and having a CCW license, the statute says that 2923, 16B doesn't apply. You can have a firearm in a vehicle, correct?
I've taught concealed carry classes, and it is not a part of the curriculum that you can have a gun in your hand while operating a motor vehicle and waving it around. That's not permitted by law.
Again, the hypothetical is not waving it around at vehicles. A person just has a gun in a car. You're saying that an officer can stop anyone driving with a gun in a car?
Well, first of all, they wouldn't know that the person had a gun in the car unless they had observed it. In this case, once again, waving a gun around or manipulating the steering wheel with the gun in hand would be, improper handling of a firearm in a motor vehicle. The CCW permit does not give you the right to do that.
The improper handling statute just says that a loaded handgun can't be in the vehicle accessible to the driver, correct? It doesn't say how it can be handled.
It has to be, a concealed carry permit does not give you the right to wave a gun around regardless of the circumstances.
That's not again, sir, I'm not asking you about waving the gun. I'm asking you about this hypothetical of Casey Goodson merely just holding the gun in his hand as he's turning left at the intersection. That's the question. So you're saying that Meade, if those were the facts confronting him, he still had a reasonable articulable suspicion of criminal activity there?
Objection, Your Honor. This has been answered.
Overruled. You can answer.
Thank you, all right. Yes, the officer would still have reasonable suspicion to investigate under those circumstances.
Just because he's merely holding a gun in a car, what is the reasonable articulable suspicion of criminal activity just by Casey Goodson holding a gun in a car?
It would be that the gun was observable and pointed in a direction other than a safe direction. Holding it in his hand or having it in his lap or whatever is not what the hypothetical is. The hypothetical is the gun is observable and pointed in unsafe directions.
But again, having a CCW license on December 4th of 2020 would allow an individual to have a loaded handgun and a vehicle, correct?
But it does not allow them to point the gun.
But again, that is not the question I'm asking. On December 4th of 2020, an individual, anybody can be, if they have a CCW license, can drive in a vehicle and have the gun in their car, visible through the windows.
Safely in their gun? Yes.
But
I'm sorry, safely in their car? Yes.
But in order to develop that reasonable articulable suspicion of criminal activity, wouldn't a reasonable officer acting under generally accepted police practices need to run the plate and identify the person in that vehicle to determine whether they have the CCW license?
Slow it down.
Yes. So on that date and time, again, we're talking about the hypothetical of Casey Goodson merely holding the gun in his hand as he's negotiating the left turn at Carl and Ferris. Wouldn't a reasonable officer need to get a little more information to conclude that there's a reasonable articulable suspicion of criminal activity by determining whether that individual had a CCW license?
You've changed the parameter of your question, Counselor. You said holding it in his hand, and then you said that the gun was observable to people outside the vehicle. Observed by a police officer outside the vehicle, that would be reasonable suspicion to at least check out whether the person has been, is being, or about to commit a crime.
Just because a person has a gun in their car, visible from the outside, that's what you're saying?
No, you're saying two different things. You're saying the person that has a gun in the car, unseen by anybody else, and then your question is turning the wheel with a gun in hand. Is that not correct, what your
Well, I'm
question
trying
was?
to ask you, I mean, you keep saying that if a person has a gun visible in their car, visible from the outside, you're saying that gives a police officer reasonable articulable suspicion that criminal activity is afoot.
If I walk up to a car and the car is parked and a person has a gun in his hand as a law enforcement officer, I have reasonable suspicion to detain that person. I don't have probable cause to arrest them, but I have reasonable suspicion to investigate to see if a crime has been committed.
Just because they have a gun in their car?
Yes.
On what basis? Because you can, and now, are you talking about now or back in December of 2020?
I'm talking regardless. A police officer has the right under Terry versus Ohio to stop and detain someone when they have reasonable suspicion to believe that a crime has been, is being, or about to be committed. We do that all the time to completely find out later on that they have a CCW permit or it's innocuous behavior. But waving a gun around or turning the wheel with a gun visible to the outside is certainly reasonable suspicion under Ohio law.
But sir, I believe you just testified that if a police officer saw an individual sitting in a car with the gun visible from the outside, that gives the officer reasonable articulable suspicion that a crime's being committed?
In Terry versus Ohio, which came out of Cleveland, the officer stopped somebody that didn't see a gun. They just, based on behavior, went up and patted the person down. So they didn't even see a gun under those circumstances. So seeing a gun, observing a firearm in a passenger compartment of a motor vehicle is reasonable suspicion, yes.
No, but sir, there has to be other facts to show that crime's afoot, especially if you're talking about the present. Ohio is a constitutional carry state now, and individuals don't even need a CCW license to concealed carry, correct?
Objection, Your Honor.
Overruled.
But we're not talking about concealed carry. We're talking about having a pistol visible, to a police officer. And that, under these circumstances, would be reasonable suspicion to stop and check Mr. Goodson out.
So sir, you are articulating to the jury that the standard that you're saying is a generally accepted police practice is that any time a person has a handgun visible from the outside of the car, the police can stop them?
I'm saying depending on the circumstances, it could be at a gun club, and that's, not the situation. But if an officer were to walk up to a passenger compartment and see a gun in the occupant's hand, that the officer would have reasonable suspicion to check that person out.
But again, you're not answering the question. I'm asking again, it sounds like the standard that you're articulating that gives a police officer to stop someone is merely just having a gun visible from the outside of the vehicle, correct?
I'm saying that whether you walk up to the car and the gun is in hand, or you see the gun being waved in the passenger compartment, that would give the officer reasonable suspicion to check the person out. That's what Terry versus Ohio is all about.
Speak over each other.
So you're saying that a police officer seeing a person holding a handgun in a car could stop them and detain them based on that?
Depending on the circumstances, yes.
What additional circumstances?
Well, if the officer sees whether the vehicles are stopped is a separate issue, but if the officer sees the subject with the gun in hand in traffic, that would give the officer reasonable suspicion to stop the person.
But you're saying it's a reasonable suspicion of improper handling?
I would say that would be a position to start to look at, to investigate. That's all Terry versus Ohio does, is allows you to detain someone to investigate if there's criminality. It could be completely innocuous behavior. The person could have a CCW permit, but if he's pointing at somebody else, that may rise to the level of crime.
Correct, and that's the additional step that the officer would need to take. They would need to see if there's a reason for them to believe that the individual in a car with a handgun, if they would need a reason to believe that they didn't have a CCW license. They can't just automatically assume that a person in a vehicle is doing it illegally, because it sounds like that's what you're saying.
No, you're conflating reasonable suspicion to detain someone. It's not arresting them, just investigating criminal activity. That's Terry v. Ohio. You're conflating that with probable cause to make an arrest. It's entirely possible that stop under Terry, where he observes the person with the gun in the car, that does not result in probable cause to arrest. But it could, and that's why police officers are allowed to stop based on reasonable suspicion and investigate.
But again, I mean, you haven't disagreed that your position is that an officer merely seeing an individual with a handgun in a car from the outside of the vehicle, they have reasonable suspicion to use their authority to stop and investigate that person. That is the standard by which you judge the circumstances of this case.
The original question was, in traffic, waving the gun around, in which I said that would arise to the level of reasonable suspicion to investigate further, to stop the person, to do a detention under Terry v. Ohio.
I mean, again, I wasn't asking that prior question. I was asking the question before you, but we'll move on because we're not getting anywhere. So with respect to the defendant's account of Casey Goodson's conduct at the intersection in this case, the only direct evidence of what happened was the written statement that you reviewed from Mr. Meade, correct?
That's correct.
Now, and again, that doesn't take into account the actual facts adduced in this trial, correct?
It does take into effect, because later on they were substantiated that Mr. Goodson was found to be in possession of a handgun.
What do you mean substantiated? You just indicated earlier in your testimony that you're not aware of any of the facts that have been adduced at this trial as to what actually happened on December 4th of 2020, correct?
At this trial, you didn't ask me about the trial. I said, when examining the case file, there is statements and there are pictures and there are videos of a handgun that was recovered on scene.
And that's what I'm asking about. You're basing your opinion on the case file. You're not basing your opinion on anything that's come out in this trial, correct?
That's correct. I was not present.
Let's move on. So your report indicated that once Goodson stopped his vehicle on Estates Place and moved with his gun in his hand towards 3996 Estates Place, he created a set of circumstances that any reasonable, prudent, and well-trained officer would have perceived as potentially deadly in nature. It's kind of the next step of the analysis, right?
Potentially deadly in nature based on the fact that the subject had a gun, yes.
So when we're talking about this point in the encounter between Mr. Meade and Casey Goodson, this is where the defendant had moved his vehicle and stopped near the intersection of Estates Place and Sale Road, correct?
That is correct.
And what's really significant in the facts and circumstances in this particular instance is that it's your understanding that Casey looked at the defendant and moved away. You found that significant, correct?
Well, it would indicate that Mr. Goodson had seen Deputy Meade of what, I don't have the ability to read his mind as to what he perceived or believed.
Okay, but the assumption then is that the defendant had a reasonable basis to believe that Casey could have perceived him as a police officer, correct? That's why you find that significant, isn't it?
Well, at some point, I believe or Deputy Meade had stated that he had announced himself U.S. Marshals and had donned protective vests with U.S. Marshals on the front. But prior to that, I don't know what Mr. Goodson saw or didn't see.
But again, we're talking about, and I'll just read the passage of the defendant's statement that you mentioned in your report. So again, the defendant wrote in his statement when he's near the intersection of Estates Place and Sale Road that I quickly got out and went to the bed of my truck. About that time, officers Rosser and Yorkowitz pulled beside me and asked what was going on. I started putting on my tactical vest and yelled that he's right there in the car at the end of the street or something to that effect. Rosser asked who I was talking about and I yelled the guy with the gun. Just then, as I put on my vest, the suspect got out of his car still holding the black pistol in his right hand. I yelled, "That's him right there. He's still got the gun in his hand." In response, the suspect looked directly at me, then turned away and started quickly moving toward the house located at 3996 Estates Place. This is the part of the incident that we're talking about, right?
Well, that you're talking about, yes.
Yeah, with you. I'm asking you about this particular segment of the incident between Mr. Meade and Casey Goodson. Are you with me?
I am.
Okay. So again, it was significant to you that Casey looked at Mr. Meade and then moved away, correct?
It was part of the totality of the circumstances. It was significant in that regard.
And again, that's because it's your finding that you believe the defendant had a basis to believe that Casey perceived him as a police officer based on the fact that Casey looked at him and then went the other direction. That's what you're saying?
I don't know what Mr. Goodson saw or what he believed at that point.
But your testimony is that Mr. Meade was reacting to the things that Casey did, right?
That's the totality of the circumstances. Those were part of Mr. Goodson's actions on Estates Place.
So Casey looks over at Mr. Meade as Mr. Meade's putting on his gear back at Sale and walks away, and then Mr. Meade indicates that he saw Casey Goodson walk towards the house, correct?
That's correct.
So again, that is showing that your opinion is that gave the defendant a basis to believe Casey perceived him as a police officer, right?
I don't know what Mr. Goodson perceived.
I'm not asking what Mr. Goodson
Don't
perceived.
talk over the witnesses.
I wouldn't know what Mr. Goodson saw or didn't. I can only, and I reported and put Mr. Meade's statement in my report of what he perceived, which is what we're talking about, not my perception of what Casey may have saw. I can only go on Deputy Meade's perceptions.
That's what I'm asking about, Deputy Meade's perceptions of Casey looking back towards Meade and walking away. You wrote in your report, and I'm on page 12. Do you have the copy of your report there?
I do.
You can turn to page 12 with me.
Yes.
So there's the large paragraph, the quote from Mr. Meade's statement, and then below that, there's a small paragraph that you wrote. That's where I'm at, okay?
Correct.
So in the middle of that paragraph, you wrote, once Goodson stopped his vehicle on Estates Place and moved with his gun in hand towards 3996 Estates Place, he created a set of circumstances that any reasonable, prudent, and well-trained officer would have perceived as potentially deadly in nature. That's the part of your opinion I'm asking about.
Oh, okay.
Yes. So again, and that's based on the fact that as Mr. Meade was at Estates Place in Sale, he saw Casey Goodson looking at him and then walking away, correct?
With a gun in hand, yes.
And again, this all assumes that the defendant had reasonable grounds to believe that Casey could have perceived him as a police officer, correct?
It doesn't make any difference what Mr. Goodson perceived or didn't perceive. The decision to use deadly force is based on Deputy Meade's perceptions, not on Mr. Goodson's perceptions.
Sir, that's what I asked you. I'm asking you, the defendant had to have reasonable grounds to believe that Casey could have perceived him as a police officer, correct? If he was standing a half mile away, and someone radioed to him that he was walking away from him, there would be no reasonable grounds for Mr. Meade to believe that Casey knew he was a police officer. You know, if he's too far away, there's no reasonable basis, correct?
I would just refer to Deputy Meade's testimony about what he perceived. I couldn't speculate on that.
And again, his perception is that he sees the suspect look at him and walk away. But again, the defendant, Mr. Meade, had to have reasonable grounds to believe that that action of Casey was somehow reacting to him, correct?
And to tell you, it was just a part of the encounter. It was not the only basis for his decision.
Yes, but I'm asking you about that encounter, correct?
You are asking me about that part of the encounter, correct?
Okay. So talking about this, and again, we're still talking about this part of the incident, which is significant, again, because Mr. Meade articulated that, and seeing Casey look at him and walk around the house, that further enhanced his suspicion that something was going on, correct?
If that's what his perceptions and his statement of his perceptions were, then we have to filter that through what a reasonable officer in the same set of circumstances would have believed.
Correct. So again, a reasonable officer in those circumstances would have to believe that somebody standing down the street and looking back at them was somehow reacting to their status as a police officer, right?
I can only refer you to what Deputy Meade said about his perceptions.
Okay. May I have the Alma, please? I want you to turn to page 7 of your report. Okay. Oh, sorry, Your Honor. May I publish? I apologize.
Yes, you may.
So, sir, are you with me on page 7?
I am, yes.
Okay, is this page 7, a copy of page 7 up on the screen?
It appears to be, yes.
Fair and accurate copy of page 7?
Yes.
Okay. So, again, the point of the encounter where Mr. Meade is seeing Mr. Goodson look at him and go away, Mr. Meade is up about right here, correct?
I would refer you to Deputy Meade's statement, but that is in keeping with his written statement, yes.
Okay, so that is 1, 2, 3, 4, 5, 6. The sixth house down from the corner of Estates and Sale, that's 3996 Estates Place, correct?
Yes.
So, and it's your understanding that when Mr. Meade's gearing up here at Estates and Sale, he's putting on his tactical vest, right? And that tactical vest bore the words on the front, U.S. Marshal, right?
Based on body-worn camera video, yes.
And that was, he's looking down at Casey Goodson down at the corner of Estates Place and Case Road, and that's the only insignia that Mr. Meade has identifying him as a law enforcement officer, correct?
I think it's on his back as well, but his vest is marked,
But
yes.
only the front of his vest is facing Mr. Goodson, correct?
I don't know what,
Lights of the pickup truck aren't on. There's law enforcement lights on it, but they weren't on at the time, correct?
I don't know about that. He does not refer to turning on lights prior.
Okay, that's your understanding of the evidence then, in your opinion?
That's based on his statement, yes.
So again, based on those facts, based on the fact that Mr. Meade was standing right here and all he had was a little chest plate that said U.S. Marshal, that gave him reasonable grounds to believe that when Casey turned around, looked back, and then walked around the side of the house, he had reasonable grounds to believe that Mr. Meade was a law enforcement officer from that distance?
You may.
I did that, I don't know. Okay. So I believe that where we left off at the break, we were discussing whether a objectively reasonable police officer standing in Mr. Meade's shoes had grounds to believe that Mr. Goodson, looking back and then, moving away from him, that reflected the fact that he believed Mr. Meade to be a police officer, correct? And you're saying that Mr. Meade had reasonable grounds to reach that conclusion?
Counselor, can you rephrase that question? It was rather convoluted.
All right. So again, we are here at this point in the encounter. Mr. Meade is at the corner of Estates Place and Sale Road, correct? Is your understanding of the evidence based on Mr. Meade's statement?
That's correct.
And again, the statement that you quote in your report, back on page 12, I did not have the right, not page 12. I have the quote here, but I didn't write the page from your report. I think it's page 7 of the report. Okay. Page 10, sir. So this, again, it's in the middle paragraph. There's a very large, or I guess I should say the top paragraph. Do you see the parenthetical or something to that effect about a third of the way down?
I'm sorry, can you, the beginning of the sentence, perhaps?
Rosser asked who I was talking about. Do you see that sentence? About
I
a
do.
third of the way down?
I do.
Okay. So again, and this is the part of Meade's statement where he's describing what's happening at Sale and Estates Place, right?
What he's describing, he can see, I believe, with the suspect in the gun, if that's what you mean.
Yes, correct.
Okay.
So, are still holding the black pistol in his right hand. I yelled, "That's him right there. He's still got the gun in his hand." In response, the suspect looked directly at me, then turned away and started quickly moving toward the house located at 3996 Estates Place. That's Mr. Meade's statement, right?
That is.
So again, you're saying that Mr. Meade, all the way up here, just wearing that little placard that says U.S. Marshal, that gave him reasonable grounds to conclude that when Casey Goodson looked and walked away, he was evading a police officer. That's your opinion.
No, that's not, all I'm doing is restating what Deputy Meade's statement was.
But again, I'm asking, did those facts and circumstances presented to Mr. Meade that I just recounted to you, did that give Mr. Meade reasonable grounds to conclude that Casey Goodson knew he was a police officer?
I don't know what Mr. Goodson, I have no statement about that. I wouldn't know.
But the officer is reacting to what Goodson's doing, and that assumes that Goodson perceives him as a police officer. The officer has to look at the facts and circumstances and reach that conclusion.
But I'm not assuming anything. I'm just recounting what Mr. Meade wrote in his report.
Okay. And in this circumstance, wouldn't the use of the lights on the truck have given Mr. Meade more solid grounds to believe that Casey understood him to believe him to be a police officer at that point in the encounter?
Police officers in these circumstances are tense, uncertain, and rapidly evolving. Turning a light switch on is something that an officer may do, but if they don't do, it's really irrelevant.
Okay, so consider this. Suppose, and again, I believe the defendant indicated that Casey was just quickly moving around the side of the house, correct? Look at the statement here. He said quickly moving toward the house located at 3996 Estates Place. That's the part that we just read about, right?
Correct.
Now, suppose the facts and circumstances confronting Mr. Meade the day of the incident showed that Casey was just walking around the house. Doesn't that affect the analysis?
Well, that would be in conflict with other witness statements in this incident, but walking or running, moving quickly, all of it, Mr. Goodson still had a gun in hand.
But sir, you are the expert on generally accepted police practices. I'm asking if the evidence showed that Casey was just walking around the side of the house with a gun, doesn't that affect the facts and circumstances presented to Mr. Meade that day?
No, the primary thing here is not the speed of movement of Mr. Goodson, but of the fact that he was moving away from the deputy with a gun in hand.
Okay. Now, with respect to this part of the incident, the original analysis, I mean, you've already said that you relied on Mr. Meade's statement, correct?
That's correct.
And you also relied on Mr. Rosser's account of the incident. That was one of the other things you looked at, isn't it?
His statement, yes, written statement.
And let's look at page 15 of your report. And I guess I should mention, there was also Officer Yorkowitz, correct?
There was. He was the passenger in Officer Rosser's vehicle.
And all three, Mr. Meade, Officer Ryan Rosser, and Officer Yorkowitz, they're all task force officers who were in the area that day, right?
That's my understanding, yes.
And you write in your report, though, that neither Officer Rosser or Officer Yorkowitz saw Goodson with a gun in his hand, correct?
Yes, they were, from what I understand, a distance behind Deputy Meade on Estates Place.
Okay. Now, again, bearing that in mind, that again, we have to rely on just Mr. Meade's statement alone that Casey was walking to the house with a gun in his hand. Suppose the facts and circumstances that were actually confronting Meade the day of the incident showed that he could have only reasonably perceived that Casey was walking to the house with a plastic bag in his hands.
This is a hypothetical.
Correct, yes.
Right, so hypothetically, you're asking me if Mr. or Deputy Meade could stop somebody with a plastic bag based on the activities prior and his reasonable suspicion that a crime was afoot. He could have stopped Mr. Goodson if he was just carrying a bag.
Okay, but he wouldn't need to approach Mr. Goodson with an assault rifle at low ready position, correct?
Well, I think it would be reasonable if you believe that the person's arm may be a deadly threat to have a gun, and that's common police practice.
So your testimony is that a person walking towards a house holding a plastic bag is a deadly threat?
No, that's not the circumstances here. We're talking about a subject that was had a gun visible in his car in the passenger compartment. That's the reason for all of this, Mr. Goodson's activities in the car. And they would rise to the level of suspicion. And certainly that officer, for officer safety, would be prudent in having a gun out and challenging that person at gunpoint.
I hear what you're saying, sir, but again, we're talking about the hypothetical. The fact finders are the jury here based on the evidence adduced at the trial in this case. So again, an officer can't look at somebody walking towards a house with a plastic bag in their hands and reasonably conclude that they can approach them with an assault rifle at low ready, correct?
Just because you get out of a car with a plastic bag in your hand and do nothing else that arises the suspicion of the police, i.e. have a gun in hand pointed at other vehicles, et cetera, if that's the hypothetical, then no. An officer wouldn't, barring other reasonable suspicion of a crime, have a reason to stop you.
Okay. Now, but you describe on page 16 of your report, let's turn there. page 16. You describe him in the second paragraph, or the first full paragraph, I should say, first sentence. You describe him as an active shooter, an obviously armed man running towards a structure, a school, business, home. That was your perception of Mr. Goodson that day?
No, you're omitting a word. I said like an active shooter event such as a school shooting, an obviously armed man running towards a structure, school, business, home, creates the reasonable perception of deadly threat. Yes.
But again, active shooter, you said it's like an active shooter event, but that occurs, an active shooter event when someone is actually shooting, correct?
I don't know, when someone is approaching a school with a gun in hand, we would define that in law enforcement as an active event, active shooter.
But they'd have to be doing more than walking with a gun, because again, in Ohio, even before constitutional carry, people in Ohio can open carry, correct? And as long as they're not on the school premises, they're allowed to do that.
Well, first of all, we're talking about an active shooter at a school as well as other structures. But if the officer had reasonable perception that the life of himself or others was being threatened with death or serious bodily harm, then he could respond with deadly force, even if it were completely innocuous.
And that's the key then. I mean, again, there has to be something more than a person just bearing a firearm, correct? There has to be more information for the officer to develop that probable cause that there's actually a threat to someone's life, correct?
Well, the officer can believe, the person doesn't even have to be armed. If an officer is walking down the sidewalk and a person comes up and makes a motion as if to draw a gun and begins to point, then the officer, if he has that's a reasonable perception that his life is being threatened with death or serious bodily harm, then he can respond with gunfire. He can use deadly force.
So again, we're talking about the part of the incident where Casey Goodson's walking from the car towards the residence, okay? And again, in this part of the incident, the only account that we have that Mr. Goodson was actually carrying a gun, that just comes from the defendant's written statement that you reviewed, correct?
Yeah, no other conflicting witness testimony is available.
Well, you didn't sit in this trial. You haven't heard any testimony, so you don't know what the witness testimony
I'm sorry,
is.
statements. There are no witness statements.
But Mr. Officer Rosser and Officer Yorkowitz, neither of them saw Casey with the gun, correct?
Doesn't make any difference. Deputy Meade's decision to use deadly force is not based on what Rosser or Yorkowitz saw or didn't see or what they perceived. His decision to use deadly force is based on what he perceived at that moment.
Well, it's based on the facts and circumstances confronting him, and that's why you look at other evidence, not just Mr. Meade's statement, but all the evidence in the case, correct?
But ultimately, the decision to use deadly force is Deputy Meade's based on his perceptions, nobody else's perceptions.
On foot around the side of the residence, okay?
Okay.
So, page 12. Your statement. So this is the quote again of Mr. Meade's statement in your report. So that is, it's in that first full paragraph there in the quoted section where it's indented. Or actually up at the top. In the seconds before firing, do you see that?
I'm sorry, in the seconds before firing, yes.
So Mr. Meade goes on to write, I loudly identified myself as a police officer and repeatedly ordered the suspect to show me his hands. However, he continuously ignored my many commands and refused to surrender. From the time I got out of my truck until the suspect opened the main door, I could not see his hands since the storm door was resting against his body and he was facing away from me with his back to me. Just before I fired, the suspect had opened the main door and taken a step forward. I ordered him to show his hands, and he abruptly stopped, sighed, and slumped forward. I've encountered very similar actions from suspects many times, and each time the suspect surrendered, leading me to believe this suspect would do the same. And then he writes that, but the moment after his shoulders drooped, he quickly turned his head and torso right in my direction to confirm my location, while he suddenly and unexpectedly started to raise his right arm back. As he did so, I saw he was still holding the gun, raising the barrel upwards in my direction. And at that point, that's when Mr. Meade makes the decision to shoot Mr. Goodson, correct? According to his account, of course.
I don't think he writes that at this point, I made the decision to shoot. But he does say, I believe he intended to shoot me at that point.
So you're saying that I misread part of the quote?
No, I'm saying that decision is not in there. It says, I believed he intended to shoot me, and that's when he made the decision, but it doesn't say decision.
Okay, so that is Mr. Meade's account of what he saw Mr. Goodson doing that day, correct?
Yes, according to his written statement.
And that's really, again, that's the sole account of what happened. That's the only thing you have, the only direct evidence of what Mr. Goodson was doing, correct?
Yes, there's no conflicting, as I said, statements or witness statements or evidence of that.
Well, again, sir, you haven't been in this trial. You don't know what conflicts, what evidence corroborates or doesn't corroborate Mr. Meade's statement, correct?
I said statements. I didn't say witness testimony.
But again, so you don't know whether the facts and circumstances actually show that perhaps the physical evidence shows that Casey did not react to the defendant's commands because he was wearing AirPods. There was no reason for the defendant to believe that.
Believe what, Counselor? I'm sorry.
That there was no evidence supporting the defendant's account that Mr. Goodson turned around and pointed a gun at him.
Is there no, once again, there's his statement and there's no other conflicting eyewitness statement that I'm aware of.
But again, I'm asking you, suppose the facts and circumstances adduced at this trial show that Mr. Meade, or that Casey did not react to Mr. Meade's commands because he was wearing AirPods. And at the moment that Mr. Meade shot him, he was simply opening the door and trying to get into his house.
I'm not aware of any statement or evidence that Deputy Meade knew that Casey Goodson had AirPods.
But again, I'm asking you the hypothetical, sir. And a police officer can't shoot somebody just walking into their house, correct?
And hypothetically, no, that's not what happened here.
Again, I'm asking you, sir, a police officer cannot shoot somebody walking into their house, correct?
Under some circumstances, yes.
Well, sir, again, this is a hypothetical. I'm asking you just to assume that assuming the facts and circumstances confronting the defendant that day indicate that Casey Goodson just didn't hear Mr. Meade. He was simply opening the door and walking into his house. Mr. Meade would not have had a reasonable basis to shoot Mr. Goodson, correct?
Because of the AirPods, is that the question?
Yeah, because he wasn't reacting because he couldn't hear. And again, Mr. Meade couldn't, assuming that he couldn't see him, but he's just seeing Mr. Goodson not reacting to his commands and going inside. That wouldn't have given Mr. Meade a basis to shoot him, right?
Mr. Goodson was not shot because of what he heard or didn't hear. He was shot because he presented at that time what Officer or Deputy Meade perceived as a deadly threat. That's the reason why he was shot.
And again, that is assuming that Mr. Meade's account of the incident is correct, right?
But that's the question you asked me, Counselor. You talked about AirPods, and what I'm saying is that I don't know what Casey Goodson did hear, could hear. I don't know whether he had earbuds in or not. It's irrelevant. The question is were Deputy Meade's perceptions of a deadly threat reasonable at the moment that he used deadly force?
Yes, and again, going back to what Graham says, it's whether the officer's actions are objectively reasonable in light of the facts and circumstances confronting them. So it's all the facts and circumstances. If the facts and circumstances don't establish, say from the physical evidence, that Mr. Goodson was actually turning and pointing his gun at Mr. Meade, then Mr. Meade had no objectively reasonable basis to shoot him, correct?
I would disagree with that. There's no way that Deputy Meade could know. My understanding is that Mr. Goodson had his hood up on his hoodie. There's nothing that I've seen in Deputy Meade's statement that he saw earbuds or was aware of that. And it wouldn't make a difference, because the question is did an armed man turn and present a gun towards a law enforcement officer and create the reasonable perception of death or serious bodily harm? That's the question.
No, the question, again, I'm not asking for your take on the evidence. I'm asking the hypothetical. Because again, sir, you haven't heard any of the evidence that's come out in this trial, correct?
If you're asking me to make an opinion about a hypothetical, I can, but that doesn't bear to the facts of this case.
But again, that's what I'm doing, because again, you don't know the facts of this case. You just know the reports and those matters that came to you from the defense team. You haven't heard any of the evidence, haven't seen any of the physical evidence that's actually come out in this trial. It's the jury's job to decide the facts, correct?
Oh, that is correct.
So if the jury decides that the facts and circumstances do not establish that Casey Goodson was pointing his gun at Mr. Meade, then doesn't that show that Mr. Meade didn't have an objectively reasonable basis to shoot him?
The question is the officer's decision based on his reasonable perceptions. That is the question. Would a reasonably prudent and well-trained officer in the exact same circumstances have used deadly force at that point? That's the question.
Yeah, and the question is, suppose the circumstances do not support Meade's account. Then he wouldn't have had a basis to shoot Mr. Goodson, correct?
That would, the jury, the trier of fact would have to make a determination of the veracity of his statement, the facts and evidence.
Okay, correct. So you acknowledge that the triers of fact have to look at all the facts and circumstances to decide whether it actually supports Mr. Meade's account of the incident, correct?
Not just his account. We have facts and evidence, for instance, the evidence of a
You don't have
gun.
evidence in this
Don't
case, sir.
speak over anyone. Let you ask a question, he answers.
I'm sorry, I do know the facts, or at least as reported. I do know the evidence as reported. Testimony I do not know, but the fact is the gun was found on scene, and it was Mr. Goodson's.
But again, you don't, those are the facts that were relayed to you for this report. You don't know any of the evidence that's actually come out in trial in this case, correct?
At trial, no, I wouldn't.
Okay, and again, it's the jury's job to decide whether the facts and circumstances confronting the defendant actually support his account of the incident, correct?
Under the standards of law, yes.
Thank you. So you gave some testimony about human factors and how an officer can process events, correct? And how that could have affected Mr. Meade that day?
It could have affected all the participants, including to some extent Mr. Goodson.
But in this case, you did not physically examine the defendant, correct?
No,
And you didn't interview the defendant, correct? To actually create a dialogue with him to examine the veracity of his account of the incident?
are we talking about veracity, or are we talking about human factors?
Well, again, the human factors, so you could have a basis to actually give an opinion on how human factors could affect Mr. Meade.
I'm sorry, when we talk about human factors, these are the things that are at play. This is how humans react in times of stress. These things have been scientifically proven, investigated, et cetera.
But again, you actually have to have evidence to show that these human factors were actually in play in a given situation, correct?
No, my report talks about how human factors can impact. I wasn't privy to or did not hear Mr. or Deputy Meade's testimony as to what he perceived in things like, perceptual narrowing, et cetera, the threat that he felt. I wasn't aware of his testimony, no.
And correct, and when you reference the sections of your report dealing with these subjects, all it includes are quotes from various sources, Law Enforcement Executive Forum, Why Zebras Don't Get Ulcers was one of the
It's one of the
sources.
foremost books on this type of thing, yes.
But again, you don't have any personal knowledge of whether any human factor was in play with Mr. Meade the day of the incident, correct?
Oh, I do, and that would be action response, as I write. In other words, a subject with a gun in hand can assault a subject, a law enforcement officer, before the officer can react and respond. With subject with a gun in hand can raise and
Your Honor,
fire.
this is non-responsive.
I disagree. I'm making, you were asking about human factors and, let him respond.
As I said, a person with a gun in hand can raise and fire before an officer can react and respond. And that includes, even if the officer has his gun on target, ready to shoot, he can still be shot by the subject before he can get off a shot.
I believe it's the Force Science Institute that looks into this.
No, this is actually, action response is a longstanding thing. Richard Schmidt, who the late Dr. Richard Schmidt, wrote about this in Human Kinetics in 1991, and it's been thoroughly studied, including people from Force Science, yes.
But you're not a person who studies it. You just read about the findings, correct?
I think when you study something, you read it, you study it, so I would disagree with that.
But you're not actually participating in these studies. You're not an
Oh,
author of
no, a
any
participant,
papers.
no.
Okay. You read about them, and
Yes,
and you're not a medical doctor, correct?
no,
And you're not a scientist.
no.
And again, you did not do any sort of physical examination, interview, anything with respect to the defendant to know anything about, what factors could have been in play with respect to Mr. Meade the day of the incident, correct?
I don't have to talk to Mr. Meade or Deputy Meade to know that a person with a gun in hand is a deadly threat, because they can always act before an officer can react and respond. I don't need to talk to anybody. That's a scientific fact.
Scientific fact just based on reading articles?
I'm sorry, this is research that's been done in the laboratory by countless people that have shown this using high-speed videography, that a subject can move and fire in as little as 0.3 of a second. And it takes an officer time to react to that and respond. So that's not, just one study or something reading about. Those are just facts. And as I said, it goes back to Schmidt, which I intended a lecture by Schmidt way back years ago.
But again, this is just based on your personal review of these findings by Schmidt and I guess other people who followed.
Everything here is my opinion based on what I've reviewed, yes.
But you don't actually do any of these studies or work in that field, whether it's psychology, medicine, et cetera, that's contributing to this research on action response, human factors, et cetera, correct?
No, I let the professionals do that.
Okay. In fact, when you were quoting or describing to us your research experience, you indicated that you've published, correct?
Yes, I've written a book, Use of Force Investigations, a Manual for Law Enforcement, as well as written extensively in the area.
And you said you wrote in periodicals.
Yes, in almost all of the major law enforcement publications, correct.
But you don't write in peer-reviewed journals, though, correct?
Well, I publish in the ILETA Journal, which is International Law Enforcement Educators and Trainers Association Journal, and that is peer-reviewed.
That's the only one, correct?
I've written for other, journals that are now defunct, but yeah, no, that's not the only one.
Okay. Now, isn't it true that you have never testified as the witness for the prosecution in a case involving a defendant who is a law enforcement officer, correct?
A criminal case, I've never testified against an officer, correct.
Okay. Thank you, that's all I have.
Any redirect?
Yes, Your Honor.
Clear out of here.
That'll be enough. Thank you.
Do you need to take a drink?
No, I'm good, just in case. I just ran out of water.
May I proceed?
You may.
Thank you, Your Honor. Mr. Shaw asked you a lot about reasonable articulable suspicion. Do you remember that, Mr. Davis?
I do, yes.
Did Deputy Meade have reasonable articulable suspicion to investigate on December 4th, 2020?
Yes.
What is that reasonable suspicion that Deputy Meade had on December 4th, 2020 in order to investigate what was occurring?
These were weapon violations, specifically the operation or the movement of the firearm inside the passenger compartment of a motor vehicle.
Mr. Shaw asked you a lot about what the defendant said. Do you remember that?
Yes,
Do you remember that he was asking you concerning the credibility of what Jason Meade said?
correct.
Was the statement that you reviewed consistent with the entire case file that I provided you?
Objection.
Want to approach? Ruling, can you ask a different question?
May I proceed?
You may.
I want to talk about materials that you reviewed in conjunction with the defendant's statement, okay?
Okay,
Mr. Shaw asked you on cross-examination a ton about if Jason Meade's statement was in fact consistent with those materials, correct?
that's correct.
Objection. That mischaracterizes my question.
Councilman, approach real quick. Without. Yeah.
So sorry. Mr. Davis, were the materials that you reviewed consistent, that you reviewed to come to your conclusion in this case consistent with Jason Meade's statement?
Yes,
Mr. Shaw asked you a lot about what Casey Goodson understood. Do you recall that?
yes,
Is Casey Goodson's understanding to come into play when analyzing the use of deadly force?
No,
Whose perception is to be analyzed when analyzing the use of deadly force?
the officer's perception.
Mr. Shaw asked you a lot about AirPods. Do you recall that?
Yes,
He asked you if Casey Goodson was simply walking into his house with AirPods in, would this shooting have been reasonable? Do you recall that?
I do, yes.
Do AirPods matter?
No,
Is that consistent with what you reviewed? Was Casey Goodson just walking into his house with AirPods in?
that's not the totality of the circumstances, no.
What are the totality of the circumstances, sir?
That Mr. Goodson had created reasonable suspicion in Deputy Meade that a crime was afoot, that Deputy Meade was attempting to investigate this, and that Casey Goodson was walking with a gun in hand towards the side door at 3996 Estates Place.
Mr. Shaw asked you a lot about the facts and circumstances and what Graham v. Connor says. He asked you about the question is whether the officer's actions are objectively reasonable in light of the facts and circumstances confronting them. Do you recall that?
I do, yes.
When Graham versus Connor says confronting them, who is that speaking about?
It's about the officer.
The officer. So does anything that Jason Meade did not know on December 4th, 2020 to come into your analysis with respect to reasonableness of deadly force?
No, the question is what a reasonably prudent and well-trained officer would have done in the exact same circumstances.
Did Jason Meade have a reason to shoot when a gun was pointed at him?
In my opinion, yes.
Is that reasonable?
Yes.
Thank you. I have no further questions.
Any questions as a result of those questions?
So, sir, just a couple questions. Your opinion about whether Mr. Meade's actions were objectively reasonable was not based on any of the evidence adduced in this trial, correct?
Witness testimony, I don't know what was introduced or not, no.
So it's just based on a paper and electronic case file provided to you by the defense team, correct?
That is correct.
But again, isn't it fair to say that in order for one to believe and agree with your opinion as to whether Mr. Meade's actions were objectively reasonable, you have to believe the credibility of Mr. Meade's statement, correct?
In light of the facts and circumstances presented, yes.
If you don't believe the credibility of Mr. Meade's statement, it's out, and his actions were objectively unreasonable, correct?
I'm not aware of any other evidence or witness statements that conflict, so yes.
But again, if his statement is found to be not credible based on the actual facts and circumstances of the event, then your opinion doesn't hold any water, correct?
I don't know about my opinion not holding any water, but it would change if that were true, yes.
Okay. Thank you.
All right, you can step down.
Thank you.
Logistically, do you guys want to come up? All right, ladies and gentlemen, you're gonna get an early release today. Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it is finally submitted to you, and same time, we'll hopefully get started at 9 o'clock. All right, everyone have a good evening.
All right.